this. So welcome everybody. So I'm Jeff Rosen. I'm one of the lawyers here at the firm. And 2020 has been a wild year, and it is quickly, or maybe for some of us slowly, coming to an end, right? So we're going to discuss critical end of year tax and estate planning items that really should be on your checklist right now, right? As I go through these, 6 major things, sit there with your own checklist and say, hey, have I been paying attention to this stuff? Is this something that would benefit me? Now, some of this stuff is stuff that you don't necessarily have to do by the end of 2020. Other things I'm going to talk about today are things that if you wait until year 2021, the opportunity to do some of this planning will be gone. So we're kind of in the twilight window of this really unique tax planning period of time in America, right? We just had an election. It was a wild election. We still don't really know what all the results are, right? There are some Senate races going on. I think everybody knows what's going on with the presidential race, if you can still call it a race. But we will have some clarity shortly. But here's the deal: depending on who controls the Senate, there could be a lot of tax changes coming our way in year 2021. So I'm glad you guys have joined us. This is what we're going to be talking about today. Now, as I go through this, I'm going to be talking about legal stuff, and I'm a lawyer, but I don't want you to construe this as legal advice, right? So I'm talking about things from a very high up general level. I don't want you to hear something I said today and decide to gift away all your assets because of something you heard. So true legal advice is what happens when you sit down one-on-one with an attorney or have a phone call with an attorney, and we have a chance to get to know your situation better, and then we can give you some pinpoint advice. So one opportunity you're going to have at the end of this is you can schedule a free phone call with me where we can go over some specific legal advice. And I got to tell you, folks, this is probably the busiest fourth quarter since I've been at the firm that we've had. There are a lot of changes abreast, and if you're a savvy person who thinks ahead and wants to make sure that you and your family and your loved ones are protected from potential changes, which I imagine is one reason you're here today, this is going to be a valuable webinar to watch. We're probably going to go for about 30 to 45 minutes today. So if you guys do have any questions, Zoom is really cool. It has a chat window and a Q&A window. And if you do have any questions, feel free to type them in and submit them there. I'll do my best to answer them throughout the presentation, but I may have to hold them until the end where we'll do a few minutes of a Q&A. So this is our team of attorneys here. We have 7 attorneys total. That's me on the bottom middle. We are all what you would consider trust lawyers. So we all specialize in estate planning, trust law, and probate law. And I would say a subset of all of those areas of practice is tax law, right? So we all understand the tax code and the potential changes that can occur to the tax code very well. So this is our wheelhouse. We're not doing divorce in the morning, car accidents in the afternoon, and a little bit of estate planning. This is what we do day in and day out. And when you are thinking about your estate plan, when you're thinking about using a particular tax planning strategy, for example, you don't want to go to a generalist, right? You want to go to somebody who's a specialist. So that's who we are. You are in the right hands with our law firm. Now, a couple of the things that I like about our firm that, in my opinion, kind of set us apart from some of the other firms that do this, because we're not the only lawyers in town who are skilled in this area. Whenever we do a living trust, we're going to try to do it on a flat fee basis. So I've had to hire a lawyer before personally, and I paid them on an hourly basis, and it was really lousy because I never knew how much it was actually going to cost until the very end of it, right? And I was nervous to call the lawyer. I knew the meter would be running, and it kept me from calling in and asking questions that I actually really wanted answers to. So we work on a flat fee basis whenever we can to eliminate that feeling that our clients might have. We do a ton of webinars for our clients. I think just this year, I've probably done 2 or 3 dozen webinars for our clients, and I know our other attorneys here have as well. Ongoing education for our clients and our potential new clients is really at the core of what keeps us going, right? This is what gets me out of bed in the morning, is the opportunity to do this and help people out, right? So I'm going to be reminding you throughout this 30-minute presentation that, we want to make it as easy as possible to get a hold of us. So at any point, if you feel like this makes sense for you, call in and schedule a free no obligation consultation or a free 15-minute phone call with me. And then once you've scheduled that at a time that's convenient for you, all you need to do is show up and I'll call you back and we will discuss what's on your mind. We could talk about specific things from this webinar, or we could talk about other things related to your estate planning as well. There are 2 numbers that you can call for free to schedule an appointment. So let's get into the material here. So this is really going to be there are so many different things that you can do in the realm of tax and estate planning. I couldn't possibly go over all of them. And, we only have less than 2 months left in the year. So you can't necessarily do, the most sophisticated planning possible, but you can do a pretty good job at doing some really good planning before year's end. So if you're going to do something prior to the end of 2020, I would consider you focus on these 6 items. Now, they may not all be applicable, but here's what I think is worthy of focus at a time like this. So the first thing is kind of a no-brainer. Have there been any changes in your life, right? Now, changes happen all the time. Tax laws change all the time, right? The probate code is kind of changing little by little every time there's an update, and there are cases being published, weekly, and that changes the law little by little. So it's always changing. That doesn't necessarily mean that they've impacted your estate plan to the degree where you need to update them. But here are some of the things that I'm seeing that are most common that really do require a change, or they have an impact on your estate plan. So first of all, no brainer here. Has anybody died, right? Has one of the owners of the trust died? Have you lost your spouse and you had set up a joint trust with your spouse? This is really important. Have any of the beneficiaries you named in your trust passed away, right? I met with one of my clients yesterday, and it was just a heartbreaking meeting because one of their children passed away, right? And they needed to rearrange their trust, redistribute the wealth. They wanted to make sure that grandchildren were included, but their grandchildren were youngsters. So they needed a plan in place for what happens if, when they pass away, if those grandkids are still underage, right? So we were able to update their trust. It was a really sad story, but folks, sometimes people do die out of order, right? And you need to address that in your plan if anybody passes away. Another big one is marriage. So if you've gotten married, you definitely need to update your trust. In fact, in California, there's a law that says if you have a trust before you get married, and then later you get married, and you never update your trust, and you end up passing away, well, your spouse probably isn't mentioned in your trust because you did that trust before you got married, right? And so California, as the default rule, they actually say, hey, by virtue of law, your spouse is entitled to a big portion of the assets of your trust when you pass away if you've omitted them. Because there's a presumption that we all want to provide for our spouse, we just never got around to updating our trust. But that's not always what people want, right? Sometimes you have a second marriage or a marriage later in life, and perhaps your trust provides that your assets go to your kids, and you never really intended for assets to go to your spouse, but California reads that into your trust. So as you've probably heard, California is a community property state. And if you have an omitted spouse in your trust and you die, your spouse gets 100% of the community property between you two, right? And that could be all the assets, potentially. It could be some of the assets, but your spouse gets 100% of the community property if you haven't updated your trust to reflect your intent on whether you want to provide for them or not. Any separate property that you have, so usually that's assets that you came into the marriage with, or something that somebody gifted you or you inherited while you were married, that's usually still separate property. That goes a percentage to your surviving spouse and a percentage to your kids. So even if you have a trust that says I leave everything to people other than this spouse, right? If you get married and you don't update your trust, that's California's default law. And we're dealing with a case where that existed right now. And, quite frankly, the surviving spouse is now fighting with their stepkids, and the litigation has become very expensive for both parties. Could have been avoided if the trust owner had updated her trust, when she got married. So, I think marriages are probably down in 2020. I have some friends who had to reschedule their wedding. But if you fall into that category or you know someone that does, this is a really important change that you need to pay attention to. Now, in the same vein related to marriage, if you have kids and your kids got married, you got to pay extra close attention to that. I have plenty of clients who say, I'm kind of concerned that, my daughter made the wrong choice and she married someone who I think is a rotten apple. And if I pass away and I leave her an inheritance, I'm going to be rolling in my grave if they get divorced one day. And, my daughter has to give up a portion of what I worked hard to leave her to this lousy ex-son-in-law of mine. And so if that is a concern of yours, and frankly, for a lot of my clients, they like their son and daughter-in-law, but I think what we all need to recognize is there's a 60% divorce rate nowadays, right? There is more likely than not chance that our loved ones are going to get divorced. And so when we're managing a plan for inherited assets, we really need to be mindful of that. Now, on a happier note, has anybody been born, right? Have you had more grandchildren? Has anything changed as far as how many people there are who are meaningful to you that you would want to support with inherited assets? So this is a big life change that, frankly, I meet with a lot of people who come in and they kind of casually will tell me, yeah, I've had some additional grandkids, or I had more kids in the last few years. But I didn't really feel it was that important to update my trust. And in some of these trust documents, they would be not included as a beneficiary unless an update to the trust was made. So that's a really big one as well. Has anyone gotten divorced? Have you gotten divorced, right? Have your kids gotten divorced? Has somebody who you intend to leave an inheritance to become divorced? And I think, some of the strains of living right now during, COVID-19, all the challenges that people have faced, what we're seeing is an increase in divorces. We're seeing, an increase in deaths, arguably. Some of this stuff, some of the specific things that people are going through in this unique year may have a really big impact on their estate plan, right? Another big one is retirement. I have about 20 clients this year who called me up and said, Jeff, I wasn't really planning on retiring, but, it's become so hard to work right now. And, I knew retirement was on the horizon, and COVID kind of forced me into retirement. I'm doing it a little prematurely, but I'm just tired of getting up every day and having to work from home, and I'm just going to do it now. And of those 20 people, over half of them have told me that they're moving out of California, right? So that's a very common thing. People are moving to Texas, Nevada, Idaho, Florida. A lot of these are states with low or no state income tax. So those are, attractive for a lot of Californians when they retire. But here's the deal. When you retire, you need to closely look at your estate plan, right? If you move to another state, you may want to have a lawyer in that state look things over. If you've recently moved to California from another state, you got to have an attorney like me really look over the documents and make sure that they reflect the laws in California that you need to be in there. And then finally, a big change that I think, unfortunately, is going to be a reality for a lot of people, maybe already, and perhaps in the next year, is bankruptcy, right? If you file for bankruptcy, you need to, really think about, how do I protect my assets, right? Is there anything you can do right now to protect your assets in the event you're going to file bankruptcy in the future? So if you're undergoing a financial hardship right now, as a result of COVID-19 impact on the economy, or for any reason, you may want to meet with an estate planning lawyer and make sure things are protected to the degree you can. Now, I'm not suggesting that you hide your assets so you don't have to pay your creditors, but there are some asset protection strategies that can be used. In the event something happens, it's not really your fault. You may want your assets to be protected in that event. So keeping up to date with the changes in your life, simple advice, really. And I think a lot of us intuitively know as our lives change, our estate plans need to change alongside it. But now is a really good time to evaluate these things because it's at year's end. It's been, a kind of a wild ride of a year where I think a lot of life changes have occurred, and you'd be doing yourself and your family and your loved ones, a valuable service to have things reviewed by an attorney. So that's number one on the checklist. Number two is another pretty obvious thing, but I think because of 2020 with health and public health and a pandemic occurring, healthcare has been on more people's minds. And frankly, if I get sick, when I think about myself and I think about potentially being admitted to the hospital for an illness, I want to make sure that if I lose the ability to communicate with my doctors as far as what my wishes are, I've clearly spelled out who I want to be in charge next. And I don't want there to be any question as to whether those are valid or whether they're going to look to another person to make those decisions for me. And I'll tell you what, I definitely don't want a physician who I've never met making all my healthcare decisions for me, right? I want somebody who I know and trust, and I know what kind of judgment they exercise, and I've had the opportunity to communicate with them what my wishes are. And I think this is really on a lot of people's mind. If you have a healthcare directive already, that's great. If you filled one out last time you visited the doctor or the hospital, that's also great. But they may be outdated, right? A healthcare directive, even though most of them don't technically expire, I would say they have a lifespan of about 5 to 6 years. If you rely on healthcare documents that were signed longer than that, there is a chance that the healthcare provider could look at that and say, hey, these have either become outdated by virtue of changes in the law, or we just feel like this represents your wishes from so long ago that we don't have the confidence that these reflect your modern wishes, right? So generally, people's healthcare documents are going to consist of an advanced healthcare directive. That's where you say, hey, this is who I want to be in charge. And this is all the contact info of the people I've designated to be in charge. So if I'm in a coma and the doctor needs to find my wife, they know where to find her, right? Her cell phone number is right there on my form. Our address is right there. And if they need to send a sheriff out to our house, they can get in contact with her and make sure that she's making my medical decisions. You may have heard of something called Hipaa before, Hipaa. That is a federal law passed years and years ago that protects the privacy of our medical records. So if you ever need to obtain the medical records of another person, like a family member, unless they've specifically authorized you as a person that can gain access, the healthcare provider is prohibited from releasing your records to them. So, I get in a mountain biking accident, I'm unconscious, they take me to the local hospital. If my wife needs to obtain my medical records, she cannot get them unless I've authorized her on a Hipaa authorization form. And folks, medical providers take this very seriously. I think the fine nowadays for a Hipaa violation is up to $250,000. So you can bet they take that very seriously. So how does this come into play today? Well, if you test positive for COVID-19 and you're receiving treatment at a hospital and the hospital is overbooked with patients and it's chaos and no one can really figure out what to do. That's kind of what's happening nowadays. I'm not saying this to scare you. That's just, what I hear is happening. Having an orderly set of documents that provides a level of organization during what is kind of a disorganized time is a really valuable thing, not only for you, but for your family members who are going to have to make those difficult decisions one day, right? And frankly, a healthcare directive deals with life-prolonging treatment, right? It indicates what your wishes are with respect to whether you want to stay on life support, whether you would be okay under certain circumstances having it removed. But it also covers just general healthcare issues, right? So I've become sick. I'm in that temporary coma. I broke my wrist in the mountain biking accident, and I can't tell the doctor whether I want to have surgery because I'm in a coma. Someone needs the authority to tell the doctor what to do on my behalf. right? So a lot of people think healthcare directive, well, that's for these really heavy, really serious medical decisions that need to be made. And to a degree, yes, it is. But it's also just for general healthcare decision making as well. Now, one of the things that I think would be really valuable, and this is kind of a nice time to do this, this is why I put this on my checklist for the end of the year, is to actually discuss with your loved ones what your wishes are when it comes to end of life treatment, right? With respect to whether you would want to be in an assisted living facility one day, or whether you'd be okay being in a skilled nursing facility if you couldn't live at home anymore. And a good time to discuss this is with your family when you all get together. Now, I don't know if everybody's planning on getting together with their family this year. It's such an anomaly of a year, but I know for us, for Thanksgiving, we're doing a Zoom Thanksgiving with all my family members. We're not actually getting together like we usually do. But when you have everybody together, it's usually a happy time. And if you start bringing up, guys, this is, what I want you to do for mom and dad when we're, at the end of our life, it's a taboo subject. It's a lousy subject to talk about. I know when I bring it up or when my parents bring it up with me, I'm like, Mom, Dad, get out of here. I don't want to talk about this. You're not going to die. We don't need to discuss this. But you do need to discuss it. And around the holidays is actually a really good time because a lot of people have an opportunity with all their loved ones together at the same time to actually talk about this stuff and actually verbalize. So a lot of people think, my kids or my loved ones, they kind of know what my wishes are. They're going to know what to do if that time eventually comes. But, frankly, they may not if you haven't actually discussed it. And that's what happened with my wife and her dad, who passed away a few years ago. He was a real tough guy, real macho man, never really expressed his feelings about this kind of sensitive stuff. And when he rapidly lost his battle with cancer and he was on life support, and we walked in and we saw him in that bed and we could tell, he was breathing on the machine, but his soul had left. It was really, really heartbreaking to see. But my wife, who had to make the decision on whether to remove him, she really had no idea what his wishes were, right? And so she kind of felt like she had to guess. She would have really appreciated if he had discussed with her what his actual wishes were. So that's the second topic here. Make sure your healthcare documents are up to date and make sure you express your wishes to your loved ones before a year's end. This is a great time to be talking about this. So the next items on the checklist are going to be a little bit more technical in nature, a little bit more geared towards actual strategies that can be utilized and added to an existing estate plan or put into a new estate plan. And here's the third thing on the checklist. Being mindful that, frankly, our landscape as we know it is changing. And what I mean by that is I think the impact of COVID-19 is, at least in California, where we're such a creditor-friendly state, it is going to increase issues that people have with potential creditors. All right, here's what I mean by this. We have people who have lost their jobs. They're on unemployment benefits. They're not making the same amount of income as they were before. People are retiring prematurely. People are, not living with the same amount of social interaction that they used to. And the result of that, if you ask me, is there's been a lot of strain on people's marriages. There's been a strain on people's businesses, on people's financial obligations. About 3 or 4 times a week, I get a call from somebody who's a business owner who says, Jeff, it's just been so difficult operating my business under these circumstances this year. I'm not making the money I need to pay my lease, and I'm in a 5-year lease. Can I get out of it? Can I break it? Right? I've got reduced income. I think we see people who are kind of prematurely selling real estate, right? They can't pay rent, and they've decided, hey, I'm going to sell this real estate. Like I mentioned earlier, you have people moving out of state, you have potential bankruptcies, and this stuff can apply to you as the owner of a trust, right? It could apply to you and impact your assets. It could also apply to your children or the people who you intend to leave an inheritance to. So why is that relevant, right? Well, if you're going to be leaving a substantial inheritance, and I think any amount of wealth you could consider substantial, right? Because I'm sure you worked really hard for it. If you're going to be leaving that to a child who's a business owner, and you can kind of forecast that they may have some challenges, one thing that may be a mistake is to, leave them as an inheritance if you pass away, a big old lump of money or a lump of assets, right? If they end up going through bankruptcy, or if they end up going through a divorce with their spouse because, the strain on the marriage that has occurred as a result of this. And frankly, one of the strains of marriage, and I'm not saying my marriage is strained at all, but me and my wife, we're like with each other all the time now. Because half the time I'm working from home and she's working from home all the time. So we're like with each other more than we ever have before. And to a degree, it's great, right? I love getting to see her, but we are definitely getting under one another's skin more often than we used to, right? And I think I get under her skin a little bit more. But that's an example of a strain on a marriage, right? I think you're in close proximity. Things just are abnormal. And I think that's testing a lot of people right now, right? And if it results in a divorce, I'm not saying that's where I'm headed at all, but for some people, I can see where that could come into play. You may want to utilize a strategy in your trust so that when you eventually pass away and you pass on your assets to these people who are your loved ones, you leave it to them in a manner where their inheritance is protected from any potential creditors they have in the future. So if they have a divorcing spouse who's coming after their assets in the divorce, if they have a bankruptcy trustee who's coming after their assets, any of these things, you have this very unique opportunity to structure your living trust in a manner where after you pass away, your trust can transform into what's called a continuing trust for your loved ones. And a continuing trust is designed to hold the inheritance for the person you've made your beneficiary. And if you want to structure it where that beneficiary is in complete control of that continuing trust, where they can manage it, they can reinvest the assets, they can pull assets and distribute them to themselves so they can spend it, you can do that. But you can design it in a manner that any assets that are kept in that continuing trust during the lifetime of that loved one are protected from their potential creditors. And that's something that isn't a new strategy. In fact, this is what I would consider modern estate planning. Probably 80% of my clients or more decide to incorporate this into their trust. And I think right now, you're going to see some of these things become a reality for a lot of families, maybe going into next year or maybe by the end of this year. And so this is a unique year where if you don't have this and you're the kind of person that says, hey, I've worked really hard for this wealth, I would hate to see it just be taken away by a creditor of the person I leave it to. You may want to consider adding a continuing trust to your estate plan for your loved ones, right? Now, this is a trust that kind of springs into existence after you pass away. So you don't set up, 3 trusts right now for each one of your 3 kids. You would put that language into your trust and it would kind of lie dormant in your trust until you pass away. Then those 3 trusts for each one of the kids spring into action and they exist to receive the inheritance you've left each one of those children, for example. So, for me, for instance, with our kids, I certainly hope that they don't have, a really nasty divorce one day or have creditor issues or get in a car accident and, be held liable for a bunch of damages. I think most of us, are hoping that that doesn't happen to our loved ones, but you never know. You don't have a crystal ball, right? And I think in this changing landscape, especially in California, so if your loved ones live in California, we are the most creditor-friendly state there is. What does that mean? It means it is easier for a creditor in California than any other state to extract assets from people, right? Creditors get paid first in California. So this is a really powerful strategy that you can employ. Now, you can do this in year 2021, but you have to have set up this structure before the asset protection is actually needed, right? And it has to be set up before you pass away, right? So if you don't do this strategy, you leave an inheritance to your loved ones, and your loved ones say, hey, it would be great if we could put some asset protection over these inherited assets. There are some options that exist, they offshore bank accounts, for example, but this is a really unique and obtainable way to create protection from the creditors of our loved ones, right? So this is checklist item number 3. Going on to number 4, I think all of us know that our country has undergone some pretty significant political change, and we've had a huge election, which will change the landscape of our country for years to come. We've got a Democratic president elect. It is unclear at the moment whether we're going to have a Democratic or a Republican Senate, but here's the deal. What a lot of analysts predict is in the coming years, perhaps in the coming months, we can have a significant change to our estate tax law. And we also call the estate tax the inheritance tax, right? So here's the rule right now. When we pass away this year, each individual can pass on $11.58 million free of inheritance tax. And if you're married, you double that because you each get one of those $11.58 million coupons. So married couples, when they pass away, can pass on $23 million and change, right? And we call that the exemption. Now, the exemption has never been as high as it is in American history as it is today, right? It has never been over 23 million. In fact, for a long time, it was, in the 90s, for instance, it was under $1 million. In 1996, that exemption amount was $600,000, right? So we've undergone this enormous increase in the exemption from that tax. Now, what do Democratic-minded politicians seek to do? They seek to lower that exemption. So the Biden plan, for instance, is to lower the inheritance tax exemption from $11.58 million to about $3.5 million. So that is really slashing the law as we know it, right? And so for a lot of families, having a $3.5 million exemption is still plenty. That's going to cover all of their assets when they pass away. But for a lot of families as well, they are either over that threshold or they are flirting with that threshold, right? They have some properties, and if the properties continue appreciating, they're on the trajectory to exceed that. So what does that mean? It means, when you pass away, if you exceed those thresholds, your family or your estate pays a 40% tax on any amount over that threshold. And frankly, that tax rate, 40%, may be changing as well. It's been 55% years ago, right? Right now it's 40%. It could change. So here's the deal. This law could potentially change next year, and it could be made retroactive back to January 1st of 2021. That's like a month and a half from now, right? Even if the law is not changed, right? Let's say there's a Republican Senate and they don't allow Biden's plan to go through, and we keep the law as we know it today. That law is still scheduled to expire by the end of year 2025. So by 2026, even if the law hasn't been changed, that $11.5 million threshold is going away, and it's going to be reduced probably to half of that, right? So what do you do if you're a person who has acquired a lot of wealth and you don't have any plans on dying by the end of this year, and you're concerned about, hey, when I eventually die, if these laws change as dramatically as they're projected to change, or frankly, as they're going to change, is there any strategy available to you right now to perhaps be able to take advantage of the preferential law today, so that in the future, when the law changes, you've already taken advantage of this $11.5 million the government gives you today? And the bottom line is there are several strategies that you can engage in to do that. And, I have a handful of clients right now who are engaging in just that. So what are some of those strategies? There are a whole bunch of different strategies available. One strategy is to gift away those assets right now. So, if you have $23 million and you're concerned that half of that's going to be gone in taxes after you pass away, you could potentially leave that to your kids or leave that to your loved ones right now. Now, a lot of people hear that and they say, that's outrageous. That's crazy. I would if I had $23 million to leave to anybody, I'm not leaving that to my kids right now. And I understand that. You could potentially use an irrevocable trust, and you can transfer assets into that irrevocable trust. It counts as a completed gift being made now. So you can use up all that exemption that you have now under today's law. And when you eventually pass away, those assets pass tax-free to your loved ones. Now that's a pretty cool strategy. If you transfer those assets to an irrevocable trust, you can potentially retain control of that trust. You can potentially retain the ability to determine who pays taxes, right? Income taxes while you're still alive on that trust. That's a strategic wealth transfer planning strategy that a lot of people are taking advantage of, quite frankly, who have acquired that much wealth, because a lot of the people we work with say, hey, I've worked so hard for this. I want to keep it within my family. I don't particularly want my family to have to write, a $10 million check to the government when we pass away. So, I know a lot of you attending here may not have estates over $23 million. If you do, frankly, if you have an estate of, I don't know, if you're married, $10 million or more. If you're single, probably $4 million or more. If you fall into that category, this may be something that makes sense to discuss with us before year's end, right? Now, why before year's end? Frankly, if you wait until 2021 to do these transfers, the law could have changed by then, right? So what we know for sure is what the law is going to be for the remainder of 2020. Let's see, I have a question here. Does the estate tax exemption amount base on the year you give, not the year you die? That is a great question. So the estate tax exemption we also refer to as the unified credit. And unified refers to the fact that this credit applies to gifts we leave when we die, but also to gifts we leave during our lifetime, right? So if I leave a gift, if I leave $1 million to my daughter this year, my $11.58 million is now reduced by $1 million. So I don't have to pay any tax on this $1 million gift that I gave my daughter while I'm alive. But when I eventually pass away, I'm not going to have, $11.5 million anymore. I'm going to have to deduct $1 million from that, right? Now the estate tax exemption, the unified credit, changes every year. So it kind of depends on the year you pass away. So if you make a gift during your lifetime, that's going to offset your existing exemption. When you eventually pass away, we add up the value of any assets that are part of your estate, and we deduct that from your existing exemption. So here's the deal. We might pass away 5 years from now, potentially, and the exemption isn't 11.5 million anymore. Let's say it's 3 million 5 years from now and we pass away. Wouldn't it be nice to have made a transfer now to use up that $11.5 million coupon we have, rather than wait until we only have a $3 million coupon and end up exceeding that, and now our family's paying 40% on the excess. So this is something that you only have a very short window of time to address. And I would suggest, if you're sensitive to that, make an appointment with us. Usually what an engagement like this looks like is somebody will hire us to do an analysis where we'll look at all your assets, we'll look at all your planning strategies available. Think of it as kind of like drawing up the architectural plans to build a house, right? And once we determine what the best strategy is, and you decide, hey, this is what makes sense, then we build that house, right? So first you kind of plan it out, then you actually implement the plan. This is a really cool strategy. Now, frankly, you might be saying, I don't really care that much about what taxes exist when I pass away, because frankly, I'm not going to be here anymore. And I'm not even going to know what taxes are being paid. And, that's a realistic way of looking at it as well. But I think a lot of the people that I work with don't have that attitude. They say, look, I've worked really hard for this. I have, I have people who are very meaningful to me, and I would prefer, if I can, to keep that wealth with them rather than just, write a check to the Treasury 9 months after my death. So being aware of the political change that's on the horizon, we've got this tiny opportunity to take advantage of this, right? Now, last bit on this topic is this is the type of strategic planning that you can't do in 2 days, right? This is something that requires that we really dive into existing assets. We usually spend weeks doing the analysis, another chunk of weeks determining what is right for your family. So this is something that takes time to implement. So if you need to implement this before the end of the year, the time to get started on this planning is now, right? And I think there's a chance that we stop taking new cases of this variety by the end of this month, because we're going to just have too much work to do in December. So if you're really sensitive to this, now's the time to jump on it and get this going. So let's see here. Going a little bit longer than I promised, but I'm real passionate about this stuff. So let's go to the 5th item on the checklist, and that is Prop 19. So if you're in California and you voted, or if you're just a Californian generally, even if you didn't vote, you've probably heard of Prop 19. This is one of the ballot measures that technically hasn't passed yet, but all signs lead to it is going to pass. They've tallied up, I think, 94% of the votes, and it's going to be shocking if Prop 19 does not officially pass. I think a lot of people are treating it as if it has passed. So what's Prop 19? It is a siege on property tax law as you know it in California. It impacts Prop 13, which you probably know what Prop 13 is, right? It limits the amount of increase the county can apply to your property for property tax purposes. So you may have bought a property for $300,000. It may be worth $1 million today, but your property tax is still calculated based on the amount you paid for it, with very small increases each year, right? So the property tax you're paying on a property now may be significantly lower than somebody who bought that same property today, right? So what does Prop 19 do? Well, the old rule says when we pass away and we transfer real estate to our children, if it's a parent to child transfer, sometimes if it's a grandparent to grandchild transfer, but that's not as common, that transfer does not yield a reassessment of property tax on that piece of real estate. And this applies to the primary residence of the parent, no matter what the value of the residence is, and up to $1 million of other property, okay? So essentially, under the existing regime that's existed for a long time, you can pass on your property, sometimes all of your properties, and not result in an increase in the property tax when the kids inherit it. And this was a tremendous advantage for people who inherited real estate from their parents, right? Whether it be their house, commercial real estate, an industrial piece of real estate, really valuable opportunity. And Prop 19 does away with that, or they at least modify it. So Prop 19 now says, when you inherit mom and dad's home, if you're going to keep the property tax where it was while mom and dad owned it, you got to live in the house. It has to become your residence. And that's the only exception that's going to exist. So if you inherit the residence and you keep it as a rental, that property gets reassessed to fair market value, right? So the property tax is usually increased significantly, right? Sometimes it's an increase of $10,000 on a residence. We have one client who owns a commercial building where if it gets reassessed when she passes away, it's going to be an increase of about $40,000 to $50,000 per year in property tax, right? So that's the impact of Prop 19. Big deal, folks. So if you're sitting there and you're saying, hey, I own real estate and one day I plan on leaving it to my kids, and I want to make sure I can take advantage of this now. How do you eliminate the impact of Prop 19? Because Prop 19 becomes effective February 21st, I believe, of 2021. And any transfers that take place have to be made before February 16th, 2021, in order to be covered by the rule as it stands today. So what does this mean? Well, potentially what some of our clients who would be really harmed by this when they pass away, right? If you have a house that you don't believe your kids are going to want to keep as their own residence, but they may want to keep it as a rental, or if you own rental properties right now that you plan on passing on to your kids and they want to keep it as rentals, right? They can't do that without a reassessment occurring on the property tax. So is there anything you can do today to take advantage of the law before it changes in February? And the answer is yes. You can potentially do several things. One idea, and this is where we're getting into the realm of, this is not legal advice, folks. These are just general ideas. I would encourage that you call us and discuss your particular circumstance, and we can give you more pinpoint advice. But one option is you can transfer that real estate to an irrevocable trust now and lock in those property taxes, right? So basically, by transferring it to an irrevocable trust, the county sees that as there's now been a change in ownership. And the law today is what's going to govern whether it's been reassessed or not. So the law today would say, no, that doesn't qualify as a reassessment. So the property taxes stay the same. When you pass away and the assets in that trust are distributed to your kids, what the tax code, what the property tax scheme is at that time, whatever year that is, really doesn't matter anymore, because you've already made that transfer this year or before February of next year, right? And this could be extraordinarily valuable for some families that have properties that have appreciated significantly, right? I mean, if you've owned your house for 5 or more years, it is most likely appreciated significantly in California, right? And I have a lot of clients who have owned their house for 40 years or 50 years. My parents, for example, have owned their house for 35 years. And, as much as I don't want them to die, one nice thing would have been to be able to inherit their house and keep their Prop 13 taxes, right? Because their Prop 13 taxes are, after 35 years, it's like nothing compared to what it would be if that house was sold today. So what I'm getting at, folks, is in order to take advantage of this, you need to do something now. And if you don't do anything and you wait until after February of 2021 and you end up passing away sometime after that, you may have left your kids with a real big property tax problem that you could have eliminated by doing something now, right? So this is a year-end thing. Technically, transfers have to be made by next February, but here's the challenge. When you record a deed transferring a property, it takes time to record it, right? And during COVID times, LA County and the counties with larger populations are taking way longer than usual to record a deed. Sometimes it takes up to 6 weeks to do that. So the time to do this planning is now, to make sure it gets recorded prior to the change in the law. Now, one other strategy that could be used potentially to take advantage of the laws today that don't involve transferring something to an irrevocable trust is you could potentially creatively structure a sale of the property to your kids now. So we have a client who was planning on moving, and they wanted to leave their house to their children. And they decided, hey, why don't we sell the house to the children now? And we can decide if we're going to gift them a portion of it or if they're going to actually pay us back for it, but we're going to sell it. We're going to memorialize the sale with a promissory note, a promise to pay for the amount of the house, and we'll structure it over a certain number of years, or we'll make it a cash sale, whatever makes sense for your family. But by selling it now, you can still apply for that parent-to-child exclusion on the real estate. So these are two really cool strategies that we're getting calls in basically every hour from people who are concerned about this. This is one particular thing where this requires such a detailed level of analysis by us that if you want to have a 1-hour consultation about this, we do charge a fee for the time it takes us to go over everything. It usually involves us trying to do a quick valuation of the property. We want to review the property tax bills, and after that work is done, we found that we need to charge a consultation fee for these types of phone calls. So if this is on your mind, call in, schedule a time to talk with me or one of the other lawyers here, and time is of the essence when it comes to this. So I'm going to go over a couple of the questions before we go over the last item on the checklist here. Let's see, is there a specific name for the spring up type trust to children that I mentioned maybe 20 minutes ago? A trust designed to protect from creditors. And frankly, every lawyer that specializes in this has a different name for it. We call it an inheritance protection trust. Some attorneys call it something else, but the concept is it's a continuing trust, right? So continuing trust is the best way to describe it. It's a trust that continues on after the original owner of the trust passes away. So that's a very good question. Let's see, another question here is, if my assets are less than the threshold or the potential changing threshold of 3.5 million, should I not worry about estate tax? That's a really intriguing question. It's tough to say because, the great mystery in life is we don't know when we're going to pass away, right? So, the law could be anything by the time we pass away. All we know is what we know now. And we can project into the future of what we think the law is going to be like, right? So for a lot of people, we can look at this time right now in history and we can say, look, we have never had a time in history where the exemption has been as high as it is. If there's going to be any change, it's very unlikely to go up. The change is likely to go down. So just to illustrate this, just a couple years ago, the estate tax exemption was $5 million, right? And then it jumped from 5 to about 10 million in 1 year, right? And we've never had a jump up that significant. So that's why a lot of people predict that there's going to be a much lower exemption. So I think even if you don't meet that, $11.58 million threshold or that $3.5 million threshold, you should still be mindful about the estate tax. And you can use your trust to prepare a plan that has a very high degree of flexibility so that if you do pass away and you are exposed to that tax threshold, you can use your trust to creatively protect those assets, right, from that tax. So those are both really good questions. So let's get into the last item on the checklist here. And this is something that I've been talking about for all of 2020, and that is the Secure Act. So this was a big change in the law that was made effective January 1st of this year, right? So 11 months ago, this law became effective. Here's the problem with the Secure Act. It has been overshadowed by the attention that COVID-19 has received. And I think most advisors and lawyers like me were really trying to communicate this to their clients at the beginning of this year, and people's attention just shifted away from this. But this is very, very important that you are aware of this change to the law. Now, the Secure Act has done several things. The thing that I think is most impactful, most worthy of paying attention to right now is the impact it's had on what happens to your retirement accounts when you pass away and other people inherit those retirement accounts, okay? So the way the law used to be before the Secure Act was when you would inherit an IRA, for instance, you'd have to pay the tax on the IRA, right? If the original owner never paid the tax on it, eventually when someone inherits it, that income tax still has to be paid, right? But you wouldn't have to pay it all up front. You could do what's called a stretch out. You could decide to keep those assets invested in the IRA over the remainder of your life expectancy and pay those taxes periodically over your lifetime. So you could stretch out your exposure to that tax, get this compound growth on the IRA, and ultimately take an inherited IRA and allow it to compound to an extraordinary value right? Deferring the tax as time goes on. It was a fantastic opportunity. The change the Secure Act has had is for most people now who inherit IRAs, they can't elect to do that life expectancy stretch out anymore. For most people, the rule that's going to apply is a 10-year rule. What that means is after 10 years of the date you inherited that retirement account, you have to pay the income tax on all of it, right? Now you can pay it all up front if you want. You can pay nothing until that 10th year is over and then pay all the income tax at once, or you can spread out the payment of that tax throughout that in that 10-year window whenever you want to, right? But when you take money out of an inherited IRA, you have to pay the income tax on it. So this has been a substantial change to the rule that existed for, frankly, dozens of years. Right? Ultimately, Congress has said, look, we want to accelerate the income tax that we receive on inherited IRAs. So there are some exceptions to this rule. You can still leave a IRA to a disabled person, and that disabled person can still qualify for the life expectancy stretch out. You can leave it to your kids if you're minors, and even though they won't receive a life expectancy stretch out, they can still get some stretch out until they become an adult before that 10-year clock starts ticking, right? But here's the deal. For most people, when they leave their IRAs to their loved ones, there's going to be a huge tax event somewhere in that 10-year window after you pass away. So is there any planning you can do to eliminate the impact of that 10-year rule? And the answer is yes. You can do what I would consider a pretty sophisticated planning strategy to offset this impact. It's what we call an Ira Legacy Trust. And this is something you can use for a 401k, a tax sheltered annuity, an IRA, a Roth IRA, anything that you would consider a retirement account is usually eligible for what we call an Ira Legacy Trust. And here's what you can do. You can structure that trust strategically to potentially give your beneficiaries the opportunity to defer the state income tax that has to be paid on that IRA more than 10 years, right? You could potentially give them more than 10 years to pay the state income tax. And that can be extraordinarily valuable to somebody. So when I think of myself, for instance, I have my parents who have been really hard workers. They're big savers. They've put a bunch of money into their IRA. I tell them to start spending it, but they're just not listening to me. I know one day when they pass away, they will be leaving me some type of money in an IRA, right? And they're probably going to pass away when I'm in my peak earning years, right? When I'm in my 50s or 60s and I'm making the most money. I have the highest income I've had in my lifetime. Now, the last thing I'm going to want to do during those peak earning years is have to realize more income as I'm forced to take the money out of the IRA that they left me, right? My preference would be to leave the money in that IRA as long as I can and defer the tax out as long as I can. So perhaps if I can, I don't want to touch that IRA money from mom and dad until I've retired and my income is lower than it used to be. And then I want to take it out. But if that window doesn't happen in 10 years, I'm out of luck. If my parents do an Ira Legacy Trust for me, they can structure it in an artful way that potentially gives me the ability to defer the state income tax, right? Not the federal income tax, the state income tax. So if I live in California, I can defer my California state income tax on that inherited IRA money past that 10-year deadline, right? The trust has to exist and it has to provide the flexibility with the language in the trust to provide that. I can't do it on my own without my parents setting up this Ira Legacy Trust for me. So if this is something, if you're a person who has contributed, I would say over $250,000 in an IRA, and you plan on leaving this to somebody one day, this is a really great planning strategy to adapt to this new change in the law. A great time to do this planning and focus on it is right now, right before year's end. So folks, that is the 6 items on the checklist that I really believe that you should be focused on before year's end. We want to make it as easy as possible for you guys. So call in, schedule a free 15-minute phone call with me, and we can go over your individual situation and determine if a longer consultation should be scheduled to really discuss what's going on. So I'm going to open it up for a Q&A. I've got some really good questions coming in here. Feel free to punch in any questions. I'll spend a few minutes on these. Let's see here. Somebody asks, if our daughter gets a continuing trust upon our death, but then commingles any community property into that trust, does that breach the divorce and creditor protection provided by the trust? That's a great question. So first of all, a continuing trust is exclusively designed to hold inherited assets. So your kids, for instance, can't say, well, I've got this inherited trust, great, let me take all my other assets that I've earned on my own and put them into this trust so I can get asset protection. It will only work to protect inherited assets. And here's the big problem with when people get an inheritance. They take that inheritance and they put it in a joint bank account with their spouse, right? They commingle it with their spouse. They use it to pay off the mortgage, and both of their names are on the mortgage. And they've now converted that inherited asset to community property. Now, if they get divorced, what happens? They split the community property 50-50. So the whole idea, or one of the major ideas behind a continuing trust, is it kind of prevents that from inadvertently happening, right? So if your daughter, for instance, receives her inheritance in a continuing trust, she's not going to be commingling those assets with her spouse, right? She's going to be keeping those inherited assets within that continuing trust. If they get divorced in the future, ex-spouse doesn't have any, they can't dip their hands into that inherited trust pot, right? That's the issue that exists. So I hope that answers your question. My house is in a trust now, and my only child's going to inherit it. He intends to live in it. Would I have to do anything for him to keep my Prop 13? Somebody mentioned an inheritance from a trust to child is different. So the distinction of whether it's inherited from a trust to a child or just directly from your name to a child is not really relevant. And frankly, if your child intends to live in it, then that's probably not going to frustrate Prop 19. So in other words, under Prop 19, so long as he inherits it from you, it's a parent to child transfer, and your child decides to make it his or her residence, that will not create a reassessment under the law. Now, there is a caveat to that, and this is something that we're still kind of waiting for clarification on, and that is when it comes to Prop 19, there's kind of a cap on a primary residence of how much value you can transfer before a reassessment occurs, even if it's used as a residence. So there's $1 million threshold. My reading of the statute or the proposition, and I'll be looking at it a little bit closer as the rules get rolled out a little bit more, is that if that reassessment yields if the reassessed value would be $1 million or more on that residence, then a percentage is still going to become reassessed, right? So they've basically said the value of the property now matters on a primary residence, and there's this $1 million buffer. So for a lot of us, we haven't seen $1 million of increase in the assessed value, so most people will be fine. But if you have a house in West LA that's gone up in value $2 million or $3 million, this would impact you. So Jessica, this is one reason where you probably still would want to schedule a consultation with a lawyer just so we can look into your specific properties and be able to tell you definitively whether this is something you need to be concerned about. So it looks like the last question I have here is, does the Secure Act 10-year withdrawal requirement apply to my spouse who's the beneficiary of my IRAs? That's a really good question. It really depends on how old you are when you pass away and how old your spouse is. So there's a chance that 10-year rule does apply, but for most people, when you pass an IRA onto a spouse, usually that spouse will do what's called a rollover to their IRA, and that restarts the age that required minimum distributions begin at. So for instance, if you're 80 and your spouse is 79 and you pass away and you've left your IRA to your 79-year-old spouse, he or she is probably going to do a rollover into an existing IRA so that they can reduce, at least for 1 year, the amount of required minimum distribution that has to come out? So that's a really good question. The Secure Act has had more of an impact on when non-spouses inherit an IRA as opposed to when a spouse inherits an IRA. So let's see, I think I may have one other question here, and a lot of these are related to Prop 19. So, you know, most of us, if we're homeowners in California, have now been impacted by Prop 19. So that's one reason that we encourage you to call in and let's talk about it. So last question I have time to answer here is, what if you inherit the family home along with your sibling and you want to buy them out and you plan to live in it? Does that affect your ability to benefit from Prop 19? That is a fantastic question. There are complete books written on this subject. Whenever you buy out a sibling, when you inherit a house, the issue is whether the county is going to see that as still being a parent to child transfer, or whether a portion of that, of which you bought them out, is now no longer considered a transfer between a parent and a child, and now it's seen as what's called a sibling to sibling transfer. So a lot of times those property tax benefits get blown if you don't structure that buyout properly. So to answer your question, there is still a way under Prop 19 to accomplish this, to keep the property tax for that one child who buys out the other, but you have to do it very carefully so as not to violate the rules. And so if you fall into this category, and frankly, guys, if you're someone who owns a house and you plan on leaving it to multiple kids, or if you're one of the kids and you know mom and dad have a house that they're going to leave to you and a sibling, for instance, and you know one of you wants to live there, the time to focus on this is now, before a death occurs, right? Because there may need to be some things in your trust or your estate plan that you need to strategically set up, so when you eventually do pass away, or when you eventually do inherit that property, you can still qualify for all these benefits, right? So if that's one thing I can convey, it's the importance of focusing on this now, rather than after someone passes away. It's a whole lot harder, and your options are much slimmer if you wait till after a person passes away to solve these potential problems. So guys, this has been a really great group of questions, and it looks like all of you hung in there until the end. So really glad you all invited us. Again, I encourage you guys, set up a free 15-minute phone call with me or another lawyer here at the firm. We'd love to talk to you about this stuff. And remember, some of these strategies are time sensitive, right? The time to focus on it is now, before a year's out. So thank you so much, everybody, and we will see you all soon. Bye-bye.